screen on mute, please, while people are speaking. Doug, that's you. Thank you. All right. Judge will start.
All right. Okay. You're good to start, please. And thank you all for being here with us today. We'll try to keep it within an hour. We know you all have plenty to do. We just want to remind you first that the next meeting of the full task force is going to be Monday, November 16th at 2 o'clock. Just please remember Monday, November 16th at 2 o'clock is our next meeting. Toward the end of this meeting, we'll be discussing some important dates, and we'll try to, again, keep you within an hour. So let's start with the first order of business, which is review of the minutes from the September 4th meeting. Those were emailed to you October 15th. So if anyone would like to unmute, if anyone has any discussion or revisions with those minutes, this is your time to please unmute and let us know if you have anything to discuss or any revisions to those minutes. All right, and thanks to Alex for sending those out. Having heard nothing, I don't see anything in a chat or anything. I'll find that those minutes have unanimously have been approved. And so now we've got on today's agenda another update from each of the subcommittees. I thank you for providing such great detail on the work that you've been doing since our last meeting. We're going to give you an opportunity to share that with everybody before we provide some final dates and so forth. So it looks like we have folks here from Data, Statutes, and Rules. I don't know who's presenting today from that subcommittee. We'll start with Data, Statutes, and Rules. Next, we'll go to the jury summoning process, followed by the implicit bias section, and then juror outreach and education. So starting with Data, Statutes, and Rules, who would like to present?
Actually, Tim and I will kind of be jointly presenting.
Great.
So I'll start and then Tim will take up the rest of it. So thanks to the particularly hard work of Chris and Ty, we have a draft of report, and our subcommittee has met regularly and gone through a lot of information compiled by Chris and others regarding what other states have done. And so we've got into some substantive recommendations that will be part of our draft report, and that includes making the juror questionnaire question on race mandatory to help in building a database regarding the actual jurors that are selected, as well as the jury pool itself. This database will be a reference point both for jurors, for the panels that are selected, as well as for the community itself. Our plan, though, is to restrict public access to personally identifiable information about the individual jurors. So that will continue to only be provided to trial counsel and will continue to only be archived for a very restricted amount of time for the purposes of people to use it for appeals and things like that, but won't be publicly available. The only data that will be available publicly will be data that cannot be identified or tied to specific individual jurors, and will only be used for research purposes. And so the juror questionnaires themselves, in terms of demographic information that will be asked, it'll include things like racial identification, ethnic identification, gender identity, and sexual orientation. Our plan is to make ethnicity and race questions mandatory, while the other questions will be entirely optional. And we've talked about using the census categories for race and ethnicity as the categories available to jurors, that we have a very robust list of categories for jurors to select from, and also to make it possible for jurors to select from multiple categories. So for instance, if someone identifies as Latina and African American, they can indicate that by selecting both categories instead of feeling constrained to only select one category. We also plan on having recommendations that would allow the judicial branch to collect data on for-cause challenges, as well as peremptory challenges, and any records collected about the challenges of jurors should reflect the identity of the first chair trial counsel as the party asserting the challenge. So there's some sort of way to track who's actually asserting the challenge to jurors. So Tim, I don't know if you want to talk about the implementation and statutory aspect of our recommendations.
Certainly. So assuming that the recommendations as outlined by Claire are adopted and approved by the task force, we see 3 levels of implementation. First is statutory, and that's 51-232, which is currently the statute setting out the jury selection process approved by the legislature. We can go one of 2 ways with that, either add to it to add the specificity of the new elements of the tracking and so forth, or alternatively, ramp it back to be more general and have it just state general goals that the judicial branch is encouraged to pursue, including identification and reduction of disparities. And which of those 2 paths to go with is really a legislative relationship question. But either way, that statute needs to be amended. Then there are a series of practice book rules that would need to be changed. We haven't reached those yet in our subcommittee. That's the next step. And then the third level of implementation is at the judicial branch's systems level. And there we see several areas. One is the judicial information forms that each juror fills out. Those will need to be revised substantially, perhaps to have 2 different forms, one with the PII, the personally identifiable information that should only be in the hands of trial counsel and should not be made a FOIA document for permanent access, versus the more aggregate information that would be permanent and publicly available. These forms should be machine readable, like our ballots, so you can check a mark and then the machine, it goes directly into a machine and nobody needs to do data input, or information about each individual juror, like name and address, which would be pre-printed. The information about the jury should indicate not just who's summoned, but also who's called for voir dire, who is challenged either peremptorily or for cause, so that we have records of any disparity in all of those levels, including whether the veneer panel as itself fairly matches the community from which it's drawn. And finally, that the courtroom clerk needs to be keeping track in real time of what's the makeup of the panel available to the counsel from whom each individual juror is being examined, because that comparison of the individual to the panel is necessary for the statistical analysis that Claire has described in previous meetings here. And then finally, I'm sorry, one more. The information being retained needs to know not only who the character of the juror, but also race of trial counsel and race of the parties, including criminal defendant, in case we want to be researching whether there's disparate treatment that depends on the race of the defendant, as opposed to just the race of the juror. So if that all sounds good, we're going to continue on that track and move next to practice book sections as well.
It's fantastic. Thank you so much. Does anyone have any questions for data statutes and rules?
I have a couple of questions. I might have missed the first part of it because I was having trouble getting on. The form collecting racial data, is that still only the form that gets returned when the juror arrives, or were you contemplating a form earlier in the process to try to get data from a broader scope of people?
I think it's earlier in the process. I think that once the person is summoned, we need at the earliest convenient time, need to have that filled out. Now, what we haven't grappled with is the possibility that some people would be able to fill it out remotely online, but other people would only be able, because of limited internet access, to fill it out when they come to court and do it in paper at that point. But the latest that it would be filled out would be upon someone's arrival at court for the first time they're summoned.
Okay, well, the first form that's returned is the form when they get their summons, the return that's claiming exemptions. And it strikes me as that's a good place to try to introduce some data gathering, because again, that's going to be a much broader pool than the people who end up showing up. And the problem has always been the people who show up in court, it's a little too late to get meaningful data from them.
Great point. Thank you. We'll adjust our recommendations to that.
That's just my thought. And the other thought is you said something about the court clerk keeping track of the flow of who's available in the pool. I would think that if you get the data accurately collected on the forms, then connected with each juror number, you'll already have that information. So the court clerk won't have to be trying to keep track of that unless there's a reason for the court clerk or somebody in the court to ask somebody's race. If you've already got the data on the race of people, then when you know what people are, who's pulled for a particular panel, then you should already be able to understand the racial makeup of that panel. Or am I missing something?
Yeah, the issue, the clerk was not expected to record information about the demographics of the individuals. What's needed is not just which juror is being examined, but also what's the current makeup of the veneer panel from which that individual is drawn. So if new people are added to that panel, there needs to be a record of that in order to compare the selectivity of that individual versus the whole group available.
Right, but that panel is going to be generated by the jury clerk in the courthouse. So again, that data should be connected to the file that's already in existence, and you should be able to access that data without, I'm just thinking of it logistically. If everything is collected correctly, then you should have that data, and all you have to do is ask, okay, juror number 5325 was sent to as an additional panelist. We have data on that jurist.
Right. All right, Claire, so we just need to confirm that and crank that into our implementation outline.
Right, I agree.
Okay. All right. Thank you.
Thank you, Harry.
All right. And what we can do is I'll make sure that every subcommittee gets a chance to address the full task force, and then we can circle back if anyone has any additional questions that, and as an alternative, we can also have people contact other subcommittee co-chairs offline with additional questions. So we've got, next we have the jury summoning process. Is anyone going to speak on the juror summoning process?
Yes, it's Harry. Well, I'll speak on that. Esther and I are co-chairs of that committee. We've divided besides dividing our tasks into subgroups.
I'm sorry, Attorney Weller, just to let you know, it looks like your camera is pointing above your head. If you mean to have it showing yourself, you might want to, there you go. All right, thank you. Go right ahead.
It's hard because it's my phone and I'll hold it. In the last meeting, we pointed out the subgroups that we've broken into. People are still doing research in the areas that I had described. First of all, we did break up our program into certain deadlines so that we would have tasks done at a certain point. The deadline for our research and collection of information that we need to try to get a handle on all the problems that we think we exist, we set for October 27th. We have moved forward the actual statutory deadline. We have people actually working on drafting statutory language on issues such as exclusions, the time that people are disqualified because they're convicts, and possible other language recommending how we make sure that people who have now had their rights to jury service restored are notified. So we have people actually working on statutory language at that point. Hopefully we can have that nailed out by the deadlines that the chairs have set by early November. So those issues we're trying to actually finalize. Here are the issues where we think we're going to get some of the most return on. One of them I want to start with is because Claire and Tim discussed it, and I have a feeling that Judge Alexander will also address it. It's this idea of the jury form itself, because the jury form acts much like a solicitation for business, and businesses spend hundreds, if not millions of dollars trying to determine how they get people to open an envelope, read what's inside, and then return what's necessary inside. We're trying to tap that area of expertise to find a way to design, both add and maybe take away some of the things from the packages, that the two notices that your jurors are sent, to make people them more productive. Because we lose people at different stages, and one of the stages may be just looking at the envelope seeing that says the envelope now says important court documents enclosed, jury administrator, and to a lot of people that might mean automatic garbage bin, or certainly not something that they would open, they would put it with bulk mail. So the idea is to trying to design a form as part of the summoning process that gets people to look at the envelope and to open it up and to read it, and also to stimulate some type of response. So that's one of the areas where we're looking at. We think that it's good to be able to do that now, and also listening to the other forms that we look like we might be changing, because the jury administrator has contracted with a new company to distribute summonses, and part of the contract is going to be the ability to redesign forms. So we think there's a very fruitful harvest that can be gained from this. So we're hoping within the next few weeks to have a little bit more detail as to some of the best methods. We already know some of the best methods for getting return. Things like instead of having a bulk mail cancellation stamp, there's a way of printing a stamp on an envelope that actually makes it look like a canceled stamp. That actually gets people to respond better. Having a letter that's actually addressed somehow personally, as opposed to something that's not addressed personally. How we would do this is another matter. But there are methodologies in this regard. We're hoping to do more than just evaluate and tell you that there are methodologies. At the end, we would like to obviously have specific methodologies we would like the committee to adopt. The second area where it looks like we're going to have an opportunity for great input, and it all depends on what technically the new program can do, is on the summonses themselves, sending them out. The new company is going to be using the National Change Redress System in an effort to reduce the number of undeliverables. And we've looked into some detail as to how that's going to work. And it has both promises and problems that we hope to have ironed out and concrete recommendations made obviously by the end of the year. Specifically, when a company, when you use the National Change Redress System, if somebody has moved and left a forwarding address, the National Change Redress System will look at that address on a proposed mailing, see that the person has moved, correct the mailing, and send it out to the new address. For our purposes, it will only send it out to a new address if it's within the same judicial district. If it's not within the same judicial district, obviously you're not going to send it out because they're not going to be qualified for jurors. So you cut down on undeliverables in that you use the National Change Redress System almost immediately. We've had several good ideas within our subcommittee, and we're hoping that the system might be able to do this. Of if you find, for example, an undeliverable in a certain zip code, to try to get the system to then send another summons, go back to the list from that jurisdiction, because the lists are divided by towns. People are summoned proportionately from towns, to maybe default to another address in that same jurisdiction, that same zip code. And we're even hoping maybe to drill down a little bit deeper if the system's able to do that. This way, we're not just going to be using the National Change Address System to ferret out bad addresses, but try to continue to keep a focus in an area where, for instance, we might lose a lot of people for undeliverables, to find the deliverable address at the outset within that zip code. And since people tend to be grouped ethnically and racially often because of zip codes, that might very much improve the deliverability of summonses, but also the deliverability to the entire swath of people that we want to reach, the broad cross-section of the community. So these are things that we see that might be a possibility within the summoning process. If it's not, then there are other issues that are arising based on this new system that the Tyler Technology is proposing. But right now, those are some of the most promising things that we're looking at for the purposes of improving the delivery and the response to the summons. And we consider, I know that the outreach group is also looking at the summons form, but obviously it's all incorporated in the summoning process. So that's the research we're doing. We're hoping to have final recommendations November 17th, and then have a full report submitted to the greater committee by the 20th of December. And of course, those dates are adjustable depending on, what the demands are of the group.
Great. Thank you so much. All right. Does anyone have any questions for the juror summoning process group? All right. Thank you so much. All right. And next we have implicit bias and Batson. Who would like to present for that segment? Oh, and Your Honor, it looks like your microphone is muted.
There we go. Is that better? Okay, thank you very much. It's Doug Levine. Dave Gold, who is the co-chair, is actually at a Rules Committee meeting, I believe, so he will try to join us later, but he may not be able to make it. I'm sitting here with Justice Katz to my right. We just spent about 2.5 or 3 hours with Dave. We're working, as I will explain, we're working on on something together. And on last week, was it last week or 2 weeks ago? We spent about 4 hours working on what I will describe to you shortly. Well, we have 3 subcommittees or working groups, as I think we have previously discussed. And one of them is the Implicit Bias Model Jury Instruction Working Group. Another one is the Peremptory Challenges Working Group. And the third one, which we are working on, is the Batson Group. And we're making progress, I think, on all of them. I believe that the last time we met, I frankly can't remember if you got reports on the progress of the Implicit Bias and the Peremptory Challenges Group. But I know Dan Krish may remember and Chris Rapillo may remember. What I was going to ask them to do, look at Harry, you're too close to you're too close to the camera. Thank you. I'm going to ask Dan and or Chris to report on their respective working groups. They have both completed preliminary reports, which we haven't really fully shared with the subcommittee yet, but we're really preparing to do that. And what we want to do is get both reports to the subcommittee and have the whole subcommittee discuss, debate on these reports. But with apologies if we're being somewhat repetitive, Dan, I'll ask you to start with, if you don't mind, with the Implicit Bias Model Jury Instruction Working Group. And then I don't know if Neil Feigensen's available or whoever can talk about the Peremptory Challenges Group. Once again, if this is somewhat repetitive, I apologize. But Dan, would you just discuss one of the groups, where you are in the report? You might want to very, very briefly summarize it. Thank you.
Sure. So I'll be extremely brief because we did report last time. There's not much new to report except that we have submitted draft written reports to Judge Levine and Judge Gold so that the whole subcommittee can review our recommendations. But the Implicit Bias Model Instruction and the Peremptory Challenges Working Group have both submitted final draft reports with recommendations.
Right. And final meaning they're going to be reviewed by now our whole subcommittee, and we'll discuss it hopefully in a meeting in the next week or 10 days and see if the entire subcommittee wants to basically ratify or put our imprimatur on what has been submitted to us, or whether we have questions, concerns, etc.
Right.
As it relates, thank you, Dan. As it relates to the peremptory challenges, I don't know if Chris, I can't see you, but if you're there, do you want to add anything to what may have previously been said? Again, the report has been provided previously, but if you have anything to add, feel free.
No, Judge, I think Dan covered it. The report's been submitted to the work group to take a look at.
Right. I would say one thing about the model jury instruction. I just want to add this. I think that people who know what our instruction is in Connecticut will note that it's really very forward-looking, and I would say it's way ahead of the curve to begin with. In fact, my understanding is very few states even have such a charge. Is that right, Dan?
That's right. 8 states and 1 federal jurisdiction.
Right. And I believe that the recommendation is to make some relatively minor modifications, but Connecticut is actually pretty far ahead in that area. Now, when it comes to the Batson Group, which is the group that I'm on and that Justice Katz is on, and a number of people who are on that group are watching, Dave Gold as well, we have spent many hours now trying to work on something that is akin to and really based on the template of Rule 37. What we are trying to do is come up with something which we believe by consensus will be agreeable to people who may have differing viewpoints. It's been a very arduous but a very rewarding process, because what we basically did was start with Rule 37 and we're working through it a line at a time, making changes, making what we think would be improvements, and trying to accommodate different points of view. In the course of doing this, I can't recall if I mentioned this, but we have spoken to two members of the Washington study group, or the group that the task force that worked on putting together and creating Rule 37. I should add, there's also a California work group that's working on a similar thing now. My guess is this is going to, sweep the country eventually. What we decided was that we would like to see something reached by consensus, because we all sort of hope that Connecticut can become a model for other states around the country. And so we're working our way through. We're almost in complete agreement, at least Joette Katz, myself, and Dave Gold have been working on this on the theory that a small group could maybe come up with something which the rest of the working group would hopefully agree with, or at least be willing to look at. And then when we get through that process, we will hope that the whole subcommittee, or the whole committee, I should say, will be willing to maybe sign on with changes and after discussion. What we anticipate, I would say it's probably likely that in the next week to 10 days, we will get whatever we've done on the Batson Group to the whole committee. I think the other reports have now been set out. By the way, the implicit bias and peremptory challenges have been sent out to the whole committee, I believe. When we get through Batson, we're going to try to have a extended meeting or meetings and talk about all three of them, and hopefully come up with general agreement. We particularly, I think it's fair to say that the Batson issue is among the most important, if not the most important, in some sense, and maybe a little more controversial than some of the others. But we're making very good progress, and I think that it's fair to say, at least, that Justice Katz, myself, and Judge Gold have really been going through it in great detail and with really terrific discussions. So my hope is in a week or 10 days we'll be able to report. I don't know if Justice Katz wants to add anything. No? Okay, she concurs. And thank you very much. And so we're really feeling pretty good about it, and we'll see where the process goes in the next week or 10 days.
That's terrific. Thank you so much. All right, does anyone have any questions, comments for the implicit bias and Batson group? Okay. All right. Thank you. It's tremendous hearing about that progress. Thank you, guys. Finally, we've got juror outreach and education. Who would like to present for juror outreach and education? Please unmute.
Good afternoon, everyone. I will be presenting today. So the subcommittee, the Juror Outreach and Education Subcommittee, we had 4 meetings to date. We reviewed the current jury outreach program as it exists today, and we reviewed the literature that is provided to prospective jurors. Every single one of us offered comments and suggested changes. For example, we suggested that parking and bus information should be included in the brochure, and that's some of the recommendations that we have made. We also have other recommendations on that we have suggested, basically.
I'm sorry to cut you off for just 1 second, but I heard you say including parking, and I couldn't hear with your audio what you said after that. You wanted to include
parking and bus information. So what buses are nearby, what train stations are nearby, so that people don't use that as an excuse, and they have better available knowledge as to what is needed of them at that point. We also discussed the parts of the program that have been successful in the past, such as partnering with high schools We believe that this partnership is a worthwhile endeavor that should be expanded and better staffed. We also discuss areas where we see an opportunity for improvement and avenues for reaching a wider audience, especially the minority communities. So each subcommittee member was assigned a task to research and then to provide recommendations in 4 areas. So the first one was community outreach. So that means that we want to identify the areas of groups in the community that can be approached to better educate the public about the jury service. This is specifically important to minority groups because we believe that minorities rely a lot on their community and that is a way to better reach them. So examples of these are churches, clubs, bar associations. We discussed how we can harvest community service to educate about jury service and remove the idea that this is a scary thing or something to get out of. We are also looking at what this program should be looking like. Are we going to be using in-person meetings, virtual meetings, brochures, what type of literature, and in what languages? Another area that we are researching is how we can approach the new citizens in the naturalization ceremony or process. So how are we going to be reaching out these new citizens? Should we have materials available at the ceremony, or do we need an in-person presence? The next area that we are researching is the high school and college outreach. As I stated before, we believe that that is a very important area to concentrate on. So how can we structure an effective but approachable program in the high school and colleges? We believe that educating the younger audience now can have a lasting impact because that means it makes our job easier in the future. The last item that we are researching is what other state outreach programs have done and what has been successful, and bring back those ideas that have been successful for those other states. Our next meeting is on October 26th, and the subcommittee members will be providing their recommendations at that time. But one area that we all agree is that the jury outreach program needs more resources and staff. Sherry DeLuca from Jury Administration has been a very vital part of this committee. She has a wealth of knowledge and experience, but the subcommittee believes that an increase in staffing and resources with her help can help reach a wider audience. She has great ideas, but needs more staffing to reach a wider audience. I want to thank every single one of my subcommittees and my co-chair, Judge Alexander, that have all been working to get a report out here. Any questions?
Attorney Mr. Augusto, thank you so much. Any questions or comments for juror outreach and education? Okay, thank you again. All right, any other questions that people have for any of the other subcommittees before we continue?
Could I jump in for a second?
Please.
Yeah. So thank you very much. These are very helpful to see where everybody is. Some of you are going to be making statutory changes. So one thing we've been talking about is that make sure that you really do need a statutory change as opposed to just a practice book change. As you know, it's going to be a lot easier to get the practice book change done. But if you do need both, if you do need the statutory change, then again, I know you all are aware of this, but just a reminder, make sure that if there is a current practice book rule, that it then is going to be consistent with any statutory change, because otherwise we're going to have a separation of powers issue, and that's never a very good thing to have. So you just want to make sure that there's consistency all the way down the line. And then I don't know if there's any questions about that. Okay, great. And then just one other thing. I'm not sure if he's on, if Chief Justice Robinson's on, but I did get the opportunity to speak with him this morning, and dates that Judge Williams is about to go through with you, he can live with. He's thrilled that we're actually going to be able to try and push this through before the end of the year. And I think that he's, without putting words into his mouth, he's committed that when we do get these recommendations to him, that then he is going to review them and take actions on the ones that he approves. So again, sort of just a boost to you all that this is not going to sit on a shelf somewhere, and he's extremely appreciative of all the work that you all have been doing thus far. So with that, I'll turn it back to you, Judge Williams.
Thank you, Justice Rogers. I appreciate that. All right, and now the tough stuff too. This is the tough part, is talking about the dates. So we've been working to try and figure out, deadlines and what everyone needs to work with whatever is proposed from the task force. And here's what we've got. So we've got the next meeting coming up on November 16, and our final task force meeting set for December 16th, through which all of the recommendations of the task force will be presented to Chief Justice Robinson. So working backward, we have some important deadlines to consider, specifically regarding the legislative recommendations. That's probably one of the more stringent ones. Recently, we were asked that any subcommittee submit proposed changes to any legislation almost immediately. I mean, the dates they were recommending were within October. After some discussion, we're asking that any drafts of legislative changes be submitted by November 9th, please. And we realize that's 3 weeks away, but seeing where the subcommittees are, it sounds like that's pretty doable. Having a concept of legislative changes is tremendously helpful as soon as you know it, but the actual, getting to roll up your sleeves and take a shot at the actual legislative language would be very helpful in moving forward with any of the recommendations. So to the extent that you're able to do that, November 9th would be the ideal date by which to propose any legislative changes. At that point, we would be able at the November 16th meeting to review any of that proposed legislative language. So that's why the November 9th date, 1 week ahead of the November 16th meeting, would be helpful. And then people will be able to discuss it at the November 16th meeting. So that's November 9th for any legislative language, please. Our meeting is November 16th. And then on December 2nd, we're asking for all final proposals of the subcommittees to be submitted to the co-chairs for review. So December 2nd is when we're asking for final proposals of the subcommittees. So that's legislative proposals by November 9th for discussion at the November 16th meeting, and then final subcommittee proposals by December 2nd for submission upon our final task force meeting of December 16th. We know that this is a very difficult time frame, but it's one that's realistic in being able to realize some of the hard work that everyone has been doing. Having that in enough time for it to be tweaked and approved through various levels so that it can actually be acted upon within the next legislative session. That's what's realistic. Does anyone wish to be heard or ask any questions about that timeline at this time? And I know it's a lot to sink in, but does anyone have anything they want to say or ask about that at this point?
Omar, could you put that in an email to everybody so we
absolutely.
Yeah.
Absolutely. The dates will be sent out. Thank you, Judge Lane. That's
Can I just pop in on the legislation itself in terms of trying to get something drafted for November 9th? It doesn't have to be perfect. It just has to conceptually, if you can do it perfectly, that would be great. It's less work for folks in the branch, but it will be reviewed by external affairs, and they'll be putting it into the format that we usually use, etc. So, don't worry if it's not absolutely perfect. And in fact, if you have questions, it may make sense to talk directly to Melissa Farley about it before you submit it on November 9th, and she may be able to give you some guidance as well.
Thank you. Any other questions on that, on any of these dates? Okay. Any other, Chief Justice Rogers, anything further on your end that you can think? Anything that we're missing?
That's all I've got, except to say thank you again to everybody. It's clear you all have been working very, very hard.
It's absolutely true. This is fantastic. These are very concrete ideas that you've come up with and have justified. And I think also I thank you all for such open thought and sharing across the subcommittees where you've had input and ideas and questions. That's been very helpful to everybody. So thank you very much. Anyone else have any questions, comments for any of the subcommittees or anything else? Wow. All right. Thank you so much for everyone's time. And as Judge Levine recommended, we will definitely make sure that all of these dates are sent out, especially to the folks who were unable to make it to this meeting. But we thank you all for all of your incredibly hard work. Thanks for providing, your comments in a brief way. And with that, anyone have anything else before we adjourn? All right. Thank you all. Enjoy the rest of your afternoon. We'll see you on November 16th. Be well.